Morning from here.
Hi. So we'll start in a bit, and my colleague Anuprada, she'll moderate the session for today. So
Okay,
she'll
perfect.
join she'll join in a bit. I think we'll start at 7:30 sharp, or maybe 5 minutes early, and then we'll go ahead from there. Would you like to share a presentation or anything?
Yes, I have a presentation.
Okay. So then I request my colleague to activate the screen share option so that you can share the screen.
I think it's already activated. Let me see.
Okay. Sure.
Now, a very warm welcome to everyone. We have today with us Lucia Ramirez, Universidad Nacional de Colombia, graduate in 2008. She has master's degree in social work with emphasis in international social welfare and poverty and inequality from University of Chicago in 2015. Lucia worked in research, teaching, litigation, and advocacy on human rights, particularly on forced migration and women rights issues, with international cooperation agencies and in non-governmental organizations. Currently, she's migration research coordinator at the Justicia. I hope I pronounced your name and everything correct. And I think we are very glad to have you here, and especially after the COVID thing, and we saw how the situation of migrant workers were, and I think we can really learn a lot from your experience and knowledge. I just request everyone to write your questions in the chat box, and we'll take all the questions at the end of the session. I hand over the session to you, Lucia. Thank you so much for coming.
Thank you so much, Anuprada. I hope that I'm pronouncing correct your name.
All right.
Hi everyone, my name is Lucia Ramirez. Thank you so much to the Center for Constitutional Rights and INCLO for the invitation. I'm very happy to be here today. I work for the Justicia as Migration Research Coordinator, and I would like to share today our experience in strategic litigation before the Constitutional Court about the right to health for undocumented migrants. The idea today is that we talk about, I want to give you a little bit of context about the Justicia's work, the situation of foreign migrations in Latin America and Colombia, and the barriers that this population experience to access to human rights, specifically the right to health, education, employment, and nationality. And finally, I would like to share with you our experience on strategic litigation to protect the right to health. So the Justicia was founded in 2004. We have been based in Colombia for about 17 years. We were founded by professors from the Universidad Nacional de Colombia and Universidad de los Andes. And our focus is research and advocacy on human rights. We dedicate to the strengthening of the rule of law and the promotion of social justice in Colombia and the Global South. And our main work strategies are research, strategic litigation, advocacy, communications, and human rights education. During these 15 years, almost 16, we have been growing as an organization. At the beginning, there were about like 10 employees, but right now we are about 80, and we have 10 different research lines or teams, and also for strategic areas which basically reflect our work strategy. So we have a strategic litigation team and communication teams and human rights education team. And all of our teams do research and human rights education and advocacy. I work for the international area at the Justicia, and I'm in charge of the migration work. So starting with the migration context in Colombia. So as you may know, Venezuela, which is our neighbor country, has experienced a crisis, a very serious political, economical, social, and humanitarian crisis since probably about the last 10, 15 years. But the migration crisis started in 2015. And currently is considered the second migration crisis after Syria. More than 5 million people have fled Venezuela, and about 34% of this population is in Colombia. So as I was saying, the first massive flow was in 2015, but since then we have experienced a continued presence of people from Venezuela in Colombia. The profile and the socio-demographic characteristics of this population are very diverse. There have been different flows. So, for example, 10 years ago, we have started receiving population, but they have like a more higher socioeconomic status, so they were able to apply for residency, to pay for the visa expenses, and to open their own companies here in Colombia or to integrate to the labor market. However, in the last 5 years, this profile have changed. A lot of people arrive and cross the region, not only the country, but the region by foot. They walk about 15,000 miles to do this journey. And during that journey, they face several risks because of the presence of armed groups and human traffickers at the borders. Also, considering that the humanitarian situation in Venezuela has worsened over the last year, they are generally people with that are in poverty and are experiencing a lot of vulnerabilities. So that also aggravates their situation when they are forced to migrate. So, sorry. Also, you have to understand that here in Colombia, it's the first time we are experiencing this type of migration flow. Even though we have been in conflict for about 60 years, and we signed a peace agreement in 2016, our country has characterized for being like one of the first countries to experience internal displacement. And actually, we were an expelling country. This means that a lot of our connationals had to leave the country to go to other places like Venezuela, Ecuador, and the United States, Central America, because of the armed conflict. And we were not, we didn't have the experience or the institutions to be a recipient country. Even though we have been historically a transit country, people cross Colombia to go to Central America and finally to the United States. Unfortunately, this type of migration have become invisible, and the institution didn't have the elements and the political will to attend this situation. So as a result of that, all immigration regulations are at the head of the executive. We don't have an immigration law, for example. Just now, since last year, the Congress has been discussing a bill about the need to have an integral political law. We don't have a comprehensive legislation that support a human rights focus to attend and to respond to the needs of this population. And so far, in these 6 years that we have been experiencing this massive migration, the response from the government has a short-term and humanitarian perspectives. So as a result, the majority of migrants and refugees coming from Venezuela experience barriers to access to fundamental rights to like health, education, work. And another factor that contributes to that situation is that in Colombia, we have a strong relationship between legal status and the access to fundamental rights. So this is a maze, this is a scheme about how the regularization routes work in Colombia. It is in Spanish, so obviously I don't hope that you understand it, but visually you can see how complicated it is to access to a legal status in Colombia. There are multiple routes, ways. However, if you see these like red squares, that shows that a lot of these ways or routes are closed right now. We only have 4 ways that people can apply, and they are open permanently. One of them is the visa process. However, in order to apply for a visa, you have to have a passport. And I'm not sure if you know this, but getting a passport in Venezuela is almost impossible. It's very expensive. There are some calculations that says that in order to pay for a passport, one person have to save 3 years of their minimum income. So that makes it impossible for most of the population to access a passport. And also the office that provides identification and official documentation to the population in Venezuela was closed last year. So people couldn't access to birth certificates, documentation, identity documents, passports, etc. So that route is almost impossible for most of the population. Then we have like some specific permits that were created to attend the needs of Venezuelan migrants. However, they require, in the majority of these permits, require that you had a passport, that you enter for a official immigration cross point, and that you stamp your passport. So as a result, even though this at the beginning, like in 2017, when these permits were implemented, it was a very good strategy. However, 3 years later, we have that 56% of the population is doesn't have immigration legal status. The majority of them don't have an status and are not able to access to the most of fundamental rights and services here in Colombia. And we also have the application for refugee status, which is open permanently. And even though we have a wider definition of the refugee status, unfortunately, the process doesn't have a legal term. The government can take as long as they need to resolve a petition. And in the meantime, people are not allowed to work. They are able to apply for health services, but they are not allowed to work. So a lot of people decide, instead of like applying for refugee status, they apply for these other permits that are not permanent. They are only for 2 years. So as a result, most of people, as I was saying, doesn't have a legal status. So they are not authorized to work, to stay in the country, and to access to government and social services. I want to make a clarification. I'm not able to see the chat. So if you have any question, can you please let me know? Okay, so that's kind of the context. So what does it mean to don't have legal status or to be an undocumented migrant in Colombia? So for example, in the case of health, you are only allowed to access to emergency care. You will not be able to receive treatment or medicine for chronic illnesses such as cancer or HIV. In terms of education, you will not be able to receive a high school degree. Even though you finish high school, you will not be able to finish it and to receive your diploma. You will not be authorized to access to higher education. And before now, currently there has been some modifications, some changes, and unfortunately that's not the case anymore. But you will not be able to take the national test, which is similar to the test in the US that is called the GED. But it's a national test that you take to prove that you acknowledge and have all the required knowledge to graduate from high school. So this is not very, I know that this is not very different from the situation that migrants and refugees experience in other parts of the world. But also in Colombia, this vulnerability has also made them the subject of xenophobic discourses by different actors like local authorities, media, and society in general. So we are a very unique country. And in this context, it's very easy to blame the stranger of our problems. In some occasions, migrants have been the scapegoat, So for example, in a national strike in 2019, they were accused by the government of promote unsafety and social disorder. So this is another layer of the vulnerabilities that migrant and refugees experience. In terms of employment, they are not out, if they are documented, they are not authorized to work. So as a result, 90% of the population work in informal settings, or like selling things in the streets, or with employers that doesn't respect their labor rights, pay them the same amount that they pay to their Colombian peers. They work more time, and they are being paid less. In terms of nationality, the children of undocumented migrants born in Colombia are not Colombian nationals, so there was a risk of statelessness. However, due to this situation, the government the Congress issued a law, and the government some regulations that allowed that children from undocumented migrants will be Colombian nationals, but only for a period of time. So this was from 2015 to 2021, and at the end of September this year, there is not clear that this law will still in place and children can acquire Colombian nationality if they were born here. So this is a little bit of the context of the Colombian situation and how we have received migrants and refugees and the challenges we are experiencing. And I don't know if you have a question here so far. I don't see. Okay. So regarding the right to health, I would like to share with you our experience and how we decided to litigate in this right. So I will have first to explain some of the legal procedures here in order to explain better what has been our journey. So first, here in Colombia, we have a sort of legal avenue or suit that is called a protective action, or a guardianship, and that's another way that is called in English. The word in Spanish is tutela. I'm gonna use that word, so please remember that that's a legal action, a protective action. That action is included in the Constitution, in the national constitution, as a fundamental right. And the idea is that every person, no matter if he's a citizen or a foreigner, it doesn't matter their legal status, their age, it doesn't matter if the person doesn't have an attorney who represents his or her interest, anybody can file a tutela, a protective action. And the idea is that you are able to advocate for the protection of your rights when the government or a private institution or a particular are acting against your rights, your fundamental rights. So you can present a tutela or a protective action before any judge in the country. It doesn't matter if the judge is an expert on the topic that you are requesting protection. And it's a very expedite process. So it takes about 10 days to the judge to decide about the case, and it has a second instance. So you can appeal if you don't agree with the decision of the judge, you can appeal, and that will be the end of the process. However, in the 1991 Constitution, we have 3 higher courts. One of these courts is the Constitutional Court, which objective of goal is to interpret and provide access to the protection of human rights. So it's the higher judicial body that can decide about these cases. It's not a third instance, but in the case of tutela, but it will review the cases that this court considered are important because there was the violation of the human rights persist, or because there is not enough jurisprudence about that topic, or because they need to unite jurisprudence and around that topic. So some of these criteria I use for the court to select the cases. So all the cases, the tutela cases from all over the country, have to go to the Constitutional Court, and based on those criteria, the court select the ones that are going to review. And in the revision process, the court can change the decision, can say like, I don't agree with the decision of the first judge or the appeal judge, so I'm gonna change that decision and protect the right. Or in other cases, could be the opposite, if the court doesn't agree with the protection of that right. So you have an idea, in only 1 year, that was 2019, sorry, here the day is wrong, but it's from January to December 2019. I'm not counting 2020 because for all of the pandemic issues, the tribunals and courts were closed. So it doesn't reflect the regular amount of legal actions that the courts receive. But so you have an idea, in 2019, the court received about 20,242 tutelas. 17% of them are about subject of special protection. And that's another concept that is important that I explained in the Colombian constitutional law, because, and I'm sure you have similar concepts back there in India, but the idea is there are some population that has been historically discriminated, or because of their situation are more vulnerable, so they need a special protection from the state. That's the case of women, children, persons with disabilities, foreigners, forced migration, internal displaced population. So the court around this population, or members of Afro-Colombian communities, indigenous communities. So the court has a special lens when they study these cases, and are always trying to protect these special groups. So that 17% of those tutelas are about subjects of special protection, and 2% of them are from people from foreign origin. So this means that also migrants and refugees are using this protective action to advocate for their rights. And what we have found is that 39% of all of the tutelas request the protection of the right to health, and that's not different for the case of migrants and refugees. When migrants and refugees decide to go to before a judge for ask for protection, the right that they advocate the most is for the protection of the right to health. So we have been monitoring. So this process where the Constitutional Court select and review the cases is a public process, is a public hearing. So since 2018, we have been able to attend these hearings, and we have documented all the cases that since that time the court has selected so far. And we found that there has been selected about 51 cases related to migration issues. And that number shows you that this is a new issue for us. So if the court selects about 620,000 tutelas every year, and that only 51 are about the rights of migrants or refugees, this means that it's still a new area for the law in Colombia, and specifically human rights and constitutional rights law. But however, even though it's a small number, 60% of the cases are about the right to health. So this means that people are not able, migrants and refugees are not able to find other avenues that are not the legal actions to ask for the protection of the right to health. And this is I think it's also the moment to provide a little bit of explanation of how the Colombian health system functions. So in general, we have a system that has some insurance that are public insurance and others that are private insurance. So if you are able to work or pay yourself for your insurance, you will be affiliated to a private insurance. But if you are not able to work, the government will affiliate you to the public health insurance. But in any of the cases, you have to have a legal document to be affiliated to the insurance. So that's the main issue with migrants, with undocumented migrants and refugees, is that they don't have a document that allows them to affiliate either the public or the private system. Second, like the other criteria that we used to decide that we were going to focus our efforts on the litigation of the right to health, there was not other legal available avenue to demand the protection of the right. So people, because they are undocumented, they are not able to file a complaint before the insurance or the local authorities. So the tutela was the only way that they could really represent themselves and advocate for their rights. And as I was saying, you don't need an attorney to represent you. So that was that has allowed a lot of people to use that tool to advocate for their rights. Also, when we review the jurisprudence before about the right to health of foreigners, because at that point we didn't even think about, or the court didn't consider them forced migrants and refugees, the judicial precedent was not favorable. So most of the cases, the court decided that you need to have a legal status in order to receive medical services beyond the emergency care. So that was very concerning, and we needed the court to understand the difficulties, and that maze that I showed you before, we needed the court to understand that it was not an option for many people to access to a legal status. And also, as I was saying, the right that people advocate the most here in Colombia, and the majority of protective actions that people file are because of the violation of the right to health. There has been a discussion here in the country about whether the judges are able to decide about something that could cost an enormous amount of money for authorities and health insurances. So this debate has been going on over so many years, and we felt that the judges have some preventions when these cases started arriving to the court, because they knew that because these people will not be insurance, someone will have to pay for those services. And this someone was the local authorities who already face a lot of difficulties to meet the needs of their population. So we wanted the judges to, and specifically the Constitutional Court, to understand that this was an issue of public policy, and that we needed also to provide a cost-benefit analysis to convince the judges to rule on our favor. So at the end, what was our goal? To achieve a progressive protection of the right. What this means, that we knew the Constitutional Court will not rule that the government will have to regulate or provide legal avenues for people to regulate their immigration status, because that will exceed their competence. But that if we focus on, for example, on the groups of subjects of the court will eventually move towards a more progressive and protective approach to those cases. So what has been our strategies and arguments? And also, I forgot to tell you, the topic of migration is new to the country, but it's also new for civil society organizations. So we have been working in this for about 2 years. We have tried to use different strategies and arguments, but still we are very young and very, we are just started our work. So our achievements are, I want you to understand our achievements in that context, that this is a topic that is really new for us also. So the first thing that we did is that we knew that we needed an interdisciplinary team to work on those cases. So we not only have attorneys, the migration team in the Justicia is only 2 people, myself and another colleague. We both are attorneys, but we team or get together with the litigation team, and they have a very interdisciplinary approach to litigation. So they have, for example, economists in their one of their members is an economy, another is an anthropologist. So we get together and have these different views of how from these disciplines we can create new arguments to approach to the court. And also because we are a very small team, for us was very important to look for alliances with other civil society organizations, not only in Colombia, but in the region. So, for example, in one of the first cases that we intervened, we wanted the court to understand that the situation of the health system in Venezuela was critical. So instead of us telling that to the court, we asked a civil society organization, ALICE in Venezuela, to submit amicus to the court explaining the situation of the right to health in Venezuela, why people, why the lack of access to health services was one of the reasons people had to flee the country. And this really resonate in the court. We received about 3 or 4 amicuses from Venezuelan organizations that were specialized in the situation of the health system there. And also, we share our case monitoring information. So every month, more or less, we submit to the organizations in the region the cases that we know that the court is going to review in the following months. Because sometimes we don't have enough time, resources, or the expertise to make an intervention in those cases. So we submit this information to our colleagues so they are able to intervene in those cases. So that has been our strategy so far. And now about our arguments. So the first one is that in general, society, but also judges and courts believe that to regularize your immigration situation is an option, that there are always routes that are available. So when they receive these cases, they say, well, you just need to apply for a legal status and your problems will be solved. But they didn't understand that there were so many barriers to access to to apply for a legal status that our first argument was to show them this maze that I already showed you that is very hard to get a legal status. And we linked that to an argument from anthropology, which is and sociology, which is the institutional indirect discrimination, which means that our legislation doesn't say the government will not provide health services to Venezuelans or to migrants. So we cannot say that there is a direct legal provision that discriminate this population on behalf of their legal status or their nationality. However, when we explain the difficulties and the barriers and the direct link between a legal status and the access to health services beyond the emergency care, we showed that there was an indirect way to discriminate them, and that discrimination was based on the institutional regulations. So we have to explain the court like how the law in practice was a form of discrimination against this population. The second argument was the cost-benefit analysis. So in this point was very important the work of one of our colleagues that was an economist. So she was able to construct an argument showing the court based on evidence from other countries, like similar countries to Colombia, that it was more expensive for the government and the state to pay for only emergency care than provide preventive health care. So for example, before pregnant women were, undocumented pregnant women were not allowed to go to prevention appointments to make sure that everything was going well with the pregnancy. They were only allowed to receive health services when they were going to give birth. So we show, like with different studies, that it was more cost effective that the government attend these women preventively. So when they went to labor, the complications reduce, and that's less expensive than only attend these complications at the moment of the labor. Or for example, with a patient of cancer, it was more economic or more, it was less expensive to attend them, to provide them the treatment that they need than attended only at the emergency care unit. That was, and we showed them that with the studies from the responses of other stakeholders in different countries, including the support of international organizations. The third argument that we used was public health, and that was specifically for the case of people who live with HIV, because the treatment for HIV is considered, because it's a medicine, is not considered an emergency care attention. Is considered a long-term treatment, and therefore is not included in the emergency care. As a result, a lot of people, migrants and refugees, are not being able to access to the treatment for HIV, and they have been without treatment for so many years because in Venezuela is not available also. So the only way that they found to access to this medicine was filing a protective action. And in 2017, one case arrived and the court decided not to protect the right of this person because they considered that the access to the treatment for HIV was not an emergency care attention or service. But then later, last year, in 2020, another case was analyzed by the court, and we were able to intervene in that case. And we used the argument of public health, saying that to deny the access to this treatment to this population not only affect them, but also affect the community, that the recipient community, and that that action was going to undermine the efforts of the government to prevent the HIV pandemic. And that argument was considered by the court. And as a result, they not only provide protection in that case, but also urge the government to take action and to design a policy to provide the treatment for this population, regardless their immigration status. The other, and this argument is very important right now, because there is currently a discussion about if undocumented migrants and refugees are able to receive the COVID-19 vaccine. So far, the government have said that because they are not able to identify this population, they cannot provide access to the vaccine. But at the end, the problem is what I was saying before, that people is not affiliated to a health insurance, and as a result, they are not able to be part of the vaccination plans because there is no way the health insurance will allow them to receive the vaccine. So this approach to public health will be very important also to litigate a case related with the access to the COVID-19 vaccine for this population. We are hoping we don't have to go that way yet, but we are using other strategies to advocate for this population. But so far it's proved that it's going to be very difficult. The other argument is the principle of solidarity. So in our constitution, this is one of the main principles. We advocate not only because the government has the obligation based on the international responsibility that is the result of the government signing all of these human rights treaties, but also because our constitution propose that the authorities need to apply the principle of solidarity in their actions. So that was an argument that we use. We know that that's not the strongest, but we also appealed to the sentiments of the judges using this principle that is in our constitution. And finally, we try to get together experts so they can provide experts' opinions about health issues. For example, in the case of HIV that I was talking about, besides talking about public health, we invite a doctor expert in HIV treatment, so he will be able to explain to the court the individual and collective consequences, health consequences of not providing the treatment for a specific group, and this really resonate with the core members, and we want to use that strategy more often with other, for example, type of illnesses. And finally, we always include in our amicus or interventions general petitions to the court. We not only ask for the protection of the rights of the people in the specific case, but also ask, for example, that the court ask the government to create a policy to provide health services for undocumented migrants, order the government to provide the HIV treatment for all people regardless of their immigration and nationality. We also have asked the court to ask the government to make public all the information about how the government is using the international financial resources that is receiving from international cooperation. So that has been so far our strategies and arguments. And what we have achieved so far. So we have intervened in about 5 cases before the Constitutional Court. And if we study how the jurisprudence have changed when we started this work, and it's not only the Justicia's work, I'm talking about civil society in general that is advocating before the court and providing legal experts' opinions. But we have achieved a wider definition of emergency care. What we have seen is that considering the judges are not going to say to the government that it has the obligation to provide legal services for all migrants regardless of their legal status, because that will imply to change the law, and that's not a competence of the court. What the court has done is open the window of what it's mean, what does mean emergency care. So, for example, the court has says, in the case of pregnant women, emergency care includes previous appointment to the labor in order to make sure that everything is going well with the pregnancy. In the case of children, because children are subject of a special protection in our constitution, any type of medical or health service that they require should be covered and should be considered an emergency care. It doesn't matter if it's a medication or it is a long-term treatment. If it is a children who is asking for that protection, it has to be warranted. And third, people with chronic and terminal illnesses. And it has been not like a consistent way the court has decided or ruled about these cases. But what we have seen is that, for example, when there is women that are head of a family household, they protect the case. Or if they are children with chronic illnesses. There has been only one case so far that is of a man that was suffering from skin cancer, and the court protect his right. But this has been the only case. In the other cases related with people with chronic and terminal illnesses is because they are subject of a special protection. And we consider that this is a very good achievement, is that the court has issued general orders. So as I was saying, for example, ordered the government to design a health policy for undocumented migrants living with HIV. It considered that there has to be a minimum of health services that include preventive care and provide dignity to this population beyond the emergency care, and ordered the government to make public the information about the use of international cooperation financial resources to make sure that is going to where it should be to provide the health services to this population. We also accompany these strategic litigation efforts with civil society efforts, because we know that unfortunately the jurisprudence of the Constitutional Court in the case of tutelas or protective actions only applies for the cases, for the individual cases, unless there is a general order. So we have advocated for changes in the legislation. So civil society organization has, for example, advocate for a immigration policy that has a human rights and long-term integration focus, has done research that has provided public policy recommendation to government, has provided orientation and legal assistance to this population, and there we have a lot of organizations that provides humanitarian assistance. And the picture that you see there was one of our advocacy efforts. So we, before the Congress, we present these 10 mandatory points that should be included in a immigration law in Colombia. And point 5 says that we need permanent regularization routes that allow people to have a legal status and in order to apply to the health system, education system, financial system, and that these regularization routes should be should take into account the situation of this population. That means that don't ask for passports, don't ask for a previous legal status, and also that recognize the vulnerability of this population. And the other point that I consider is important for this conversation is that we ask that the law has a human rights focus, because as I was saying before, The focus so far has been in a humanitarian assistance and a short-term perspective. These points were submitted to Congress members for different, like you can see here, all the organizations that support this initiative, and the bill is currently being discussed at Congress. However, 2 weeks ago, and I'm not sure if you heard the news there, but the Colombian government announced that it was going to create a new permit or a statute that provide a legal immigration status to all the people that was in the Colombian territory before January 31st, regularly or irregularly. So this is great news. We hope that with this statute, a lot of people can regularize their situation and overcome the difficulties to access to the right to health, among others. However, as civil society, we need to be very vigilant. The announcement is right now that an announcement. There is not yet a legislation that supports that announcement. There is a draft of the decree who is going to implement that that statute, but we have some concerns about that decree because it requests, for example, that you provide your biometric data. This means your fingerprints, your iris, I don't know if that's the word in English, a photograph, and those are requirements that, like, for example, the iris print is not something that we request for Colombian nationals. So we're very worried about how this information is going to be used and if it can be used against the migrants population. And another concern that we have with that decree is that doesn't guarantee the due process in the immigration proceedings, but instead the migration authority has a lot of discretionality to decide who is going to receive the permit or who doesn't. So we are advocating for that this new permit, which is a very important move and has been appraised nationally and internationally at how of like one of the most important decisions that has been made to protect the rights of migrants and refugees in the region, has this focus and fulfill its promise to provide legal status and, more than that, a human rights protection to this population who is very needed of that approach. So I'm going to leave it there. Thank you so much for your attention, and I hope we can have a fruitful discussion. Thank you very much.
Does anyone have any questions? I can see one question here, which says that are passports required for migration from one state to another state in USA and Colombia?
Yes. Yes.
Can you hear me, Lucia?
Yes, I hear you. Do you hear me? Do you hear me?
Yes, I can hear you. There's one question in the chat box which says that are passports required for migration from one state to another state in USA and Colombia?
Yes. Unfortunately, do you hear me?
Yes, I can hear you.
Okay, perfect. So I was saying that, yes, unfortunately, countries require passports to go to one to another within the region. So a lot of people that are moving through the region So they come to Colombia, but they continue going, for example, to Peru or Ecuador or Chile or Argentina. They do it without documentation. So that exposes them to many risks along the way.
Okay. So I just have another question. When you talk about migration, are you talking about, is there also migration within the country, within Colombia, or it's only from one state, one country to another in South
No,
America?
we had internal migration. We have been the second country in the world with more internal displaced population for so many years due to our armed conflict. So people migrate from rural areas to the main cities due to this violence. But paradoxically, we haven't used that knowledge and that experience to attend migrants and refugees. So a lot of organizations that before were working with internal displaced population, they moved to work also with migrants and refugees, but that has not been the case of the government.
Ma'am, I have a question.
Sure.
Yeah.
Yes, go ahead.
So I was wondering, just like the European Union, why doesn't the South American or the Latin American like have any union sort of thing that will make internal movement easier for all Latinos? Like, is there something like that which they can come up with?
Yeah, that's a very interesting question, because actually we have that, but Venezuelan government retired from those agreements. So they are not currently being part of the Comunidad Andina de Naciones, which is very similar to the European Union. So many countries don't allow people without passports to come into their countries due to that lack of reciprocity. But before, for example, Colombians, we are able to go to Ecuador, I believe Argentina, only with our ID. But that's not the case for Venezuelans, because the government quit these international organizations.
Okay, so Lucia, there was some interruption. You can share the presentation now. We've given the permission. I'm sorry for interrupting you. Yes.
Sure, I will submit it to you, so you can please share with the attendees.
You want to share it now, or you'll be circulating it?
Oh, did you see? Did you see the presentation or? Okay. Let me see.
Yes.
Something. Let me try again. Do you want me to submit it like as an attachment?
Yes, you can send. We can circulate as well. It's up to you.
Okay, I will do it right now.
Okay.
I see another question in the chat. So like India is Colombia has forced migration. Yes, as I was saying, we were one of the main countries that has internal forced migration. We have about 11 million people that was forced to migrate from the rural areas to the cities due to the armed conflict. I am sending the presentation right now. I hope you receive it in a bit.
Okay, all right. Does anyone have any other question? I just have one more question. Are there social security schemes for the migrants in Colombia? So, and how are you able to utilize those schemes for the people? because in India we have thousands of schemes, but when it comes, because the people don't have documentation, so that becomes a major problem.
Yeah, we experience the same situation. There has been a lot of networks that produce fake documents, and people have to pay a lot of money for that. That's an effort that is to prevent that is being doing mostly from the government. They provide information about what is a legal document, that all of these permits are for free. You don't have to pay for that. But the problem is that you don't have documents to apply to them, right? So, but that's very difficult to control. And even though there is a lot of information, a lot of people is forced to go to that route because they don't have other alternatives.
Okay. If no one has any questions, should I conclude the session now? Okay. So thank you, Lucia. Thank you so much. You are doing an amazing work, and we hope to take whatever you said from the session, where you will try to utilize it here as well. Thank you for coming here and speaking, and I'll share the document with everyone as well, the presentation which you shared. And thank you everyone for joining. Have a good night and good wishes. Bye.
Thank you so much for the invitation. I hope this was helpful for the work you are doing there.
Yes, definitely it was. Thank you.
And please reach out if you have any questions. I'm not sure if the presentation, because it's still uploading.
We can ask you if we've not received it. I'll ask you. We have your email. We'll ask you for that.
Yeah, I will send you by email. I think it's easier.
Yes.
Okay, have a good night.
Thank you, everyone. Good night.